Hi there and welcome to yet another video. In this channel, we are more keen on walking the journey with employers as far as HR functions are concerned. And today we are discussing a very interesting topic regarding employment contracts. The question is, in what circumstances is it legal for an employer to change or even to modify an employment contract? I believe you will find this very interesting, and I'm glad to be joined by our lead HR consultant, Mr. Paminas, in this conversation. Thank you so much for joining in.
Thank you for having me.
Yes. I know a contract sometimes is a binding document between two parties, but yes, it can be modified, it can be changed depending on how things unfold. So as far as employer-employee relationship is concerned, is it legal, and under what circumstances can an employer modify or even change an employment contract?
So apart from the contract defining the terms of engagement, let's not forget that it's an agreement that is entered into voluntarily. So the basis of any agreement, any contract, whether it's employment or sale, purchase, that kind, is the key aspect here that it's voluntary. Both parties want to get into a contract. So it then goes without saying that any changes that you need to make to this contract must also be acceptable to both parties.
To both parties, yeah.
They must be acceptable to both parties. Yeah. So in that sense, what are some of the things you may want to change within the terms of the contract? So it could be things like salary. It could be things like the working hours. There could be a change in the law, the labor law. For example, right now there's a discussion on the sick leave. The current terms of sick leave is 7 days on full pay and 7 days on half pay. There's a bill which was taken to Parliament. It's only been debated, where they were talking about raising it to 15 days each. So now the first 15 days are on full pay, the next 15 days on half pay. So if there's a changes in law, you can also change the contract to reflect
the new changes.
The new changes, yeah. So in terms of the law then, whenever you are making a change that favors an employee, there is normally no dispute. I'm yet to hear of an employee taking an employer to court because they've added them a salary. There's a higher pay.
Like something changed in the contract in their favor.
In their favor, precisely. So whenever any change that favors an employee is welcome. Obvious. Why? Because an employee is looked as the weaker party. In this instance, yeah. So with that in mind, then any change that is putting an employee to the so-called disadvantage, the employee must consent. That's as far as making changes to a contract is, you can make a change to the contract, but ask yourself, is it disadvantaging the employee? If it is, then you have to seek consent. You have to agree with the employee, and then if you're in agreement, only then can you change the terms of the contract. If you don't agree, then you're inviting another discussion, which is termination of that contract. I'll give you an example. Let's say the company is not doing well, and we saw this happen during COVID. So maybe I'm able to afford a certain salary, but now there's no business. So many of the firms, where there was good relationship between the employer and the employee, were able to sit and see, what can we do? So Mary agreed to a pay cut, and that went on record that you voluntarily agreed to a pay cut. And we start a new relationship, now based on the new salary. But if Mary had come and said, no, I'm not in agreement with that pay cut, then the termination process starts. And then what is the reason for termination? It could be redundancy. And then this is what, as an employer, you're supposed to do. Yeah. So any employer watching this video is to realize you only have one option. Get into the discussion with the employee if the change is going to affect the employee negatively. And this makes sense, whichever way you look at it. Mary was used to a certain budget. Now I want to pay you low because I'm not doing well. Where is the fairness? There has to be fairness, because you are used to a certain budget. But now I'm telling you, I'll pay you lower. There's also fairness for the employer, because if the employer cannot be able to pay you the much they were paying you, then it's only fair you exit that position. I hire someone who can
take the
who
offer.
can take the new offer.
The new offer.
So can you see where discussion comes in and how it helps both parties? Yeah. Because Mary can come and say, I'm okay the next 3 months as the situation improves. And that is acceptable. If it's acceptable to the employer, well and good. But if you come and look at your finances and you say, for me, I still need my former pay. So the law allows that contract to be terminated. And then the employer gets someone who can be able to take up on that. Yeah.
Great. Now, the one key advice that you would give to employers regarding this issue of circumstances under which it is legal to modify an employment contract, because I do believe it's a very sensitive area as far as employer-employee relationship is concerned.
As an employer, you only have 2 options. Communicate, 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 and then follow the due process. That's the only thing.
Wow.
Communicate, share. This is the reality, this is where I am. Try to co-opt the employee in all ways that you can. Minutes, have minutes, show that you discussed. If then the situation cannot be averted, you follow the due process. So if it's Mary's termination, it's done the proper way. All her dues are paid. And paying of dues does not mean tomorrow I have to pay you everything. For example, there are so many companies we've consulted and assisted on the issue of redundancy. So if the company cannot afford to pay Mary or the amount, we enter into a payment plan. We say we owe Mary 300,000, we will pay you in 4 months installment. And that's allowed in law, because I'm not running away from my obligation as an employer. Yeah, so communicate, engage the employee as much as possible. But then if the situation cannot be averted, don't be emotional, because sometimes I see employers saying, but she knows we aren't making money.
They should never assume.
Yeah, don't assume. Because you had a contract. The minute you realize there were financial hardships, what did you do? Yeah, so don't be emotional, just follow the due process. And that way, it is not only the right thing to do, but it's also the legal thing to do. Yeah, you'll have averted this matter escalating now to the courts. And seek experts. That's why we are here as corporate staffing services. Yeah, so we'll come in, advise you on these are the steps that you're supposed to take. This is the communication. We are a registered and recognized HR firm by the law. So we'll take you through every step of the way. Yeah, so come to us. The meeting, the first meeting is a free consultation meeting. We will not charge you. We want to understand where we are coming from, the scope of the work, and after that we can agree on how to handle the matter. Yeah.
Great. Thank you so much for sharing with us.
You're welcome.
Indeed, that is why we are here. As Paminaz has mentioned, we are able to have a conversation with you as far as matters to do with HR is concerned, and most importantly, how to ensure that you follow the due diligence, the processes as far as changing or modifying any employment contract is concerned. The link below will guide you on how to reach out to us, and we will be glad to have a conversation with you and come in handy in support of HR matters within your organization. Thank you so much for watching this video, and see you in the next one.